Today we're going to talk about grass, and I don't mean the kind that grows in your backyard. A question that I get asked fairly often in family law consultations is, what happens if I indulge in a little Mary Jane every now and again? Over the past year, I would say, that question has evolved to encompass CBD, Delta-8, Delta-9, and other kinds of cannabis derivatives or cannabinoid derivatives. The answer to that question is kind of nuanced. It really depends, first of all, on what kind of case you have. In your divorce without minor children, your consumption of marijuana, THC derivatives, CBD, Delta-8, Delta-9, probably not going to be a big deal. And why do I say that? There are no kids involved. So in a relative sense, the stakes of your consumption are not very high. That being said, marijuana still isn't legal in Texas. So from a criminal standpoint, perhaps it's not something we should be talking about should we ever have to have a hearing in court. But if you're getting divorced and you don't have children and there is no way that your consumption of marijuana can endanger the life of another person, I can't ever say anything with 100%, none of us can, but it's more likely that whether you smoke marijuana in a case like that may not be really dispositive, may not really change the outcome of your case. Medical marijuana, on the other hand, in very limited situations in Texas is legal. Those situations are purely severe health event related. So you see sometimes medical marijuana prescribed in cases of cancer where cancer is severe, it's very progressed, the patient is in a tremendous amount of pain. Other medical marijuana cases are going to be similar to that. CBD, Delta-8, and Delta-9, all three of those are technically legal in Texas as long as the THC threshold falls below 0.3%. So when is my consumption of CBD, Delta-8, Delta-9, or marijuana going to impact my family law case? Almost 100% of the time are cases where there are children involved, whether that's a divorce with minor children or a SAPCR, a suit affecting the parent-child relationship. If you consume marijuana or if you use CBD or Delta-8 or Delta-9, it's possible, and if the opposing party knows about it, I would say it's fairly likely that that issue is going to come up in court. It is very common for a party or both parties in family law cases involving children to request drug testing. Why do we request drug testing? Well, we want to be sure that every decision that we make is in the best interest of the children. And of course, there is always a concern that if you're consuming cannabis or a cannabinoid derivative, that your mental state, that your functionality, that your judgment could be affected, particularly when you have your children in your possession. So how do judges feel about things like Delta-8 and Delta-9, which are technically legal in Texas? Well, as of a few months ago, drug testing companies around the DFW area did not have breakdowns for THC and THC derivatives. There was typically just one column for cannabis or cannabinoid or marijuana. And so when you drug tested, if you were taking Delta-8 and Delta-9 and you did have the threshold level in your system, chances are that the drug test was going to come back positive, which could substantially negatively affect you in your family law case. Now, many drug testing companies, including the one that we use most prevalently here in Tarrant County, actually have a breakdown for Delta-8 and sometimes even Delta-9, though it's less common. So your drug test may come back negative for THC, but positive for Delta-8 because of the varying thresholds of THC levels in marijuana and in Delta-8. As far as judges are concerned, primarily here in Tarrant County, Delta-8 and Delta-9 are legal as long as I mentioned, the THC level is below that 0.3% threshold that is legal across the state. So as I said, we can't ever promise anything, but chances are if you get a drug test and it comes back negative for marijuana, but positive for Delta-8, that isn't really going to affect the judge's view of you, your case, and how you should be able to interact with your your children. That's not to say that that is a hard and fast rule. Every judge has different preferences and different predilections, and it is entirely possible that a judge may know about Delta 8, may have read up on it, and may know that Delta 8 does have the side effect or the effect of letting you feel high or of altering your mental state, even only slightly. Now, because Delta 8 is such a relatively untried issue, particularly in the family courts, there isn't a whole lot of case law. There isn't a whole lot of experience, really, that many family law attorneys have had with judges regarding the Delta 8 and even Delta 9. So every case is really going to be kind of a proving ground as we move forward with cannabinoids and cannabis derivatives. Marijuana, on the other hand, pretty hard and fast, as I mentioned, still illegal in Texas unless you have a medical marijuana prescription. That being said, there are a couple of judges here in Tarrant County that, perhaps not on the record, but off the record, at least in informal conversations, have indicated that they may have a little bit more flexibility regarding marijuana usage, particularly if, for example, you were to travel to a state like Colorado or like California where marijuana usage is legal, and you were to partake there and to return here and get a drug test, and that marijuana, that THC would still be in your system. Do I recommend testing out that theory? Not necessarily, and definitely not in every court, especially not in Tarrant County. However, as the legal landscape regarding marijuana legality and marijuana usage changes federally, state-wise, we may see a shift in the law and a shift, of course, in judicial philosophy. So what did we learn? Marijuana, still not legal in Texas. If you are currently involved in a family law case, whether that is a divorce or a suit affecting parent-child relationship, and you do currently partake in a little Mary Jane, perhaps take a step back, maybe start cutting yourself off a little bit, maybe explore an alternative like Delta 8 or Delta 9, which are both legal here in Texas as long as they remain below that 0.3% saturation THC threshold. Thank you so much for watching. If you have any questions or comments, you can leave them down below. For more family law content, make sure to subscribe. And otherwise, you can find us at familytexas.com.